Okay, good afternoon. We will call to order this meeting of the Marathon County Public Safety Committee, and we will start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we will move on to item 3. We do not have anybody registered for public comment. We can move on to item 4, which is approval of the June 11th, 2024 meeting minutes. Do we have a motion to approve? Motion by Mass, second by Wilhelm. All those in favor?
Aye.
Any opposed? Aye as well. Motion carries. We can move on to item 5, policy issues, discussion, and potential committee determination. Item A, discussion regarding 2025 annual budget development and policy recommendations from the committee, including review of the mandatory discretionary program documents and discussion of rates and fees. Item 1 is consideration to continue funding for the Women's Community Service Contract in the 2025 annual budget. And we have an educational presentation.
Mr. Chair, I'll kick it off with just again an overview for item 5A. You can have any budget discussions you want. The agenda item is broadly worded so that you can discuss the mandatory discretionary program list, any of the issues underneath under the umbrella of this committee's purview, rates and fees. But specifically, if you recall, the budget process document that the county board approved earlier this year calls for each of the respective standing committees that have jurisdiction relative to funding of particular nonprofits to take a look at the work of those nonprofits under the service contracts that exist. And you have 2 that are appearing before you today. And again, you can have any conversation relative to budget. We have a number of department heads here that can answer specific questions. But if we are ready to proceed to the women's community presentation, we have Jane Graham Jennings here to kind of walk through what that performance contract, that services contract provides for, and it is for your own kind of context. It's within the budget document, specifically on page 144. But if it's okay with you, Mr. Chair, Jane, you can come right on up here and talk through the work of the women's community and additional information and answer any questions. And their annual report is available online, which I think Jane is handing out copies right now. So that certainly is something that the supervisors can take a look at.
Thank you.
Here's your annual report.
Great. Good afternoon. So the annual report that I passed out is all of the services that the women's community provides. It has everything that we did in 2023, our numbers, services, special events that we did, in addition to our financial breakdown. So you can see where the county funding fits into our overall agency breakdown. Specific to the county funds and the deliverables that we provide to the county. So where's that page? Yeah. So particular things that we are contracted with the county to provide. One includes partnering with the district attorney's office to meet with victim witness in providing support services to survivors of domestic violence, sexual assault, stalking, and human trafficking. And so in 2023, we had 173 contacts with the district attorney's office. There's a process called probation review or a domestic violence compliance court where people who are charged with domestic abuse and they are on probation, they must attend review hearings to ensure that they're following the rules. So we're attending those to see the impact that that's having on victims and if there is accountability for offenders. So we attended 20 of those in 2023. We're currently in the process of kind of revamping that to make sure that it's successful. There's been some changeover in probation and parole staff, so we're working with all of that to make sure that that's still up and running and going to be responsive to victims and hold perpetrators accountable. We also contract to provide a diversion program, mostly for youth who are in situations with sexting, which can create a whole lot of issues for young people who don't understand the consequences of sending nude photos. So instead of bringing them fully into the criminal justice system, we use a diversion program that really provides education to young people about responsive behaviors. And our family advocate provides that information and support to young people to make better choices and to really think about what's best for their future. We also contract to provide sexual assault education in Marathon County schools. And at the end of our week-long sessions that we do, we have a panel discussion that includes staff from District Attorney's Office, from law enforcement, from Sexual Assault Nurse Examiner program, to kind of walk through what a typical case of sexual assault would look like. So we have a week-long in the schools doing prevention education with students, and then we have a panel presentation. In 2023, we had approximately 500 hours of prevention education in Wausau School District. We are very excited that in 2024, we are finally able to get into the DC Everest School District. So we will be expanding our prevention education program to DC Everest District twice a year going forward. So we'll be doing 6 times a year in the Wausau and Everest school districts. We also are contracted to provide support services when we get contacts from Marathon County Sheriff's Department for victims of domestic abuse. In 2023, we had a total of 79 calls from the Sheriff's Department for victims of domestic abuse, and we were providing 40 follow-up calls to those. In addition to, if we can't get in contact with the victim, then we send out outreach letters to them. Another partnership that works really well with the District Attorney's Office and also with the Sheriff's Department is with a special investigator. So when we don't get those calls from the deputy, the special investigator can then connect our advocates to the victims at a later time. So what typically happens is that there's an arrest for domestic abuse, a deputy would contact the agency to give information. Things come up, if they have to run immediately to another call, it's a busy night, they may not be able to reach out to us. So when we work with a special investigator, they're able to make that connection with us that the deputies weren't able to make immediately at that time. So it's another partnership that we have with county staff. And lastly, we're contracted to provide advocacy and follow-up services to the families who go through the Child Advocacy Center. So when children are, there's an accusation of abuse or neglect, we provide all the advocacy services at the Child Advocacy Center and do the long-term follow-up with the children and families. In 2023, we responded to 132 victims at the Child Advocacy Center, and that was about 531 hours funded by the county for the Child Advocacy Center. So those are our contracted services. That's what we provide and do. And then there's also a note that there's a statute for marriage license fees, and those funds go to support our shelter staff. So the $25,000 we get from marriage license fees pays for our staff to stay overnight in our shelter program. So that's our county funds. Any questions that anyone has?
Any questions? Thank you.
Thank you.
And are we looking for a motion to recommend continuation at this time?
That would be in order. Just again, for context, the budget process document that was approved calls for each of the standing committees to take up and review the funding that is allocated through the annual budget through these performance service contracts. What I'm looking for is essentially direction to continue to either build the budget as it has been the last several years, as Jane alluded to with the existing contract, or if you are looking for something different. So if you were seeking to continue to provide funding in the budget that I would develop and turn over to the board, that would be your motion to continue funding as provided in the 2025 budget as was provided in the 2024 budget.
Do we have a motion, Supervisor Mask? Motion to continue funding.
I know that you probably don't know exactly numbers, but it doesn't look like we're going to need funding for other things, or are we kind of on par for how we've been with? I'm just curious where we are funding-wise for 2025.
Sure. We just received late last week the net new construction estimates for the preliminary estimates for the net new construction for the county, and it's 1.72, which is slightly down from last year, but still puts us in terms of additional new revenue in about the same position relative to other counties in the state. I think last year we were 10th, and my quick skim through the counties put us in the same boat. So we'll have to figure out kind of where we are in terms of new revenue. Every year in the county budget, it's pretty similar in terms of the new revenue you're bringing in is net new construction. We hope for some additional shared revenue dollars, which last year we kind of now finally have some clarity on what those numbers are going to be. It's about 20,000 additional dollars. So I guess at this point, I don't know that I can answer your question very well, but I need direction on what to work to include at this point.
And this is really just a policy directive to incorporate into the budget.
Correct, and you will have the opportunity, as you do each and every year, to amend the budget, both at the HR Finance and Property Committee once I turn it over, and of course, after the public hearing as you debate the budget.
So we have a motion on the table by Supervisor Mask to continue funding in the 2025 budget as has been developed in the 2024 budget. And we have a motion by Supervisor, or a second by Supervisor Hoppe. Any discussion? Supervisor Zhang, you're online. Did you have any discussion?
No, I was going to second it, but since it's already been second, I'm okay. Thank you.
Any further discussion? Supervisor Mask.
Thank you. Over the years, I've heard the different reports from the women's community, and knowing how much good they do in saving people's lives and helping people move forward, it would be a sin to not ever finance this program, at least at where it's at right now. So I firmly believe it's a very good use of our money.
Thank you. Any further discussion? Okay, hearing none, all those in favor of the motion signify by saying aye. Aye as well. Any opposed? Okay, that carries, and we can move on to item 5A2, consideration to continue funding for the Judicare mediation service contract in the 2025 annual budget. And again, we have an educational presentation.
Sure, and I'll kick it off. Same story, different nonprofit. So beginning, I believe in 2020 was the first year that this program was funded by Marathon County. It was initially funded through an allocation of funds, I understand, from the Sheriff's Office budget to Wisconsin Judicare to deliver mediation services for various types of court actions, most notably eviction cases, with the thought being that freeing up judicial time through the use of mediation would allow us to continue to devote sufficient resources to processing criminal cases. So before you today is Randy Westgate from Wisconsin Judicare, as well as Judge Strasser from the courts. For context, the funding amount is $15,000 that has been annually allocated since the 2020 budget. And within your packet today, I believe on page, I will find it here, beginning on page 58 is the professional services contract that Randy will be referring to in terms of the deliverables. They're set forth in that document, and I will scroll to that page, but without further ado, I'll kick it off to Mr. Westgate and Judge Strasser.
Thank you. Again, I'm Randy Westgate. I'm the Director of Mediation for Judicare, and we operate the mediation system for the Marathon County court systems in small claims cases. I've given you what was our report to the committee last year, which showed basically what we do, how we do it. So I've included that in for basic information for those who may not have been here last year or whatever. We receive about $15,000 from the county, but at the end of it, you will find at the end of that report, there's this chart, which is basically our 2023 cases. Last year was very interesting for us because it was the first time that we were able to be in court all the time and see an entire year that wasn't particularly affected by the pandemic. In small claims last year, you can see there were 2,516 cases that went through. Small claims is a very busy place for the judges. And if you look at that chart, it basically shows all of the different types of cases across the top that we handle: evictions and damages cases, debt collection, regular small claims, and replevin cases. This is a pattern that has existed throughout as far as we can see, recording the data, that about 66% of the cases default because the people don't show up and participate. One of our major efforts is to be able to reduce that. But once we're able to get through, and the judges do the return dates, and that's a very quick process where if somebody doesn't show up, they basically get defaulted. But of the 859 cases that were heard in small claims court, we were able to resolve without them coming into the court cases 93% of the time. It is not because we're great mediators, it's because that the nature of the eviction cases and the debt cases are easily settled by mediation, probably much better. A judge can evict or not evict. We get to operate between those lines. We can work out payment arrangements. We can work out pay and stay arrangements. We can rent out move-out arrangements to avoid the evictions. But what we're extremely proud of is if you look at and what probably concerns you most, in eviction and damages cases, there were only 14 eviction hearings last year in Marathon County, which is quite remarkable considering, because these are the people that are, if they are evicted and they don't have any resources, these are the people who end up to be homeless. And so our job is to try to prevent that eviction if we can. And I will tell you that the landlords are extremely helpful in this. We have a very good set of landlords here. They have concerns about getting their units and making sure they get the rent on time and everything, but they work with these people, and mediation gives them a chance to do that. For 2023, there were 63 small claims trials in total, which out of 2,516 cases is a good chunk of those cases getting out of the system before they have to reach the judges. What we also discovered was that there were a lot of cases that we were able to resolve, for example, by getting the people, if they needed to move out, they couldn't exist within in their apartment or their unit, and they needed to leave, we were able to negotiate people able to, move out and avoid the eviction on their record, because that's the key to the whole thing in the eviction part of it. There's also a heavy debt collection part, where people then are garnished if they're found that they are liable for past debts and money collections. So it allows for $15,000, it allows the mediation to take a lot of these cases and be able to work them for the courts. We work for settlements. They all go to the judges. The judges can sign them or not sign them, but basically it frees them up to be able to handle much more important and monetary cases instead of these small claims cases. And I'll let Judge Strasser tell you a little bit just about what his experience is in how that affects his docket and what he does as a judge.
Thank you. Well, actually, I talk to all the judges on a regular basis about this and other issues. And the idea was that, and the $15,000 that the program is asking for doesn't pay for the full program, right? So it's a contribution from the county. And the idea is that when we are on intake, each judge does intake for a week. There's 6 judges, so every 6th week you're up for intake. There was a slot assigned for evictions that was taking a lot of time, and the promise to the county board when we started this was if this mediation program is as successful as we believe it's going to be, we will use that time to try to move criminal cases forward and or resolve them. And there's no way for me to say here today, yes, well, here's the exact number of cases that we move forward or resolve because of mediation. But what I can tell you is that all the judges all of them, believe this was a good idea. They all believe that it is freeing up their calendar to do that. And as a result, we do have fewer cases. The case, we're very cognizant of the number of cases we have because, well, it's good as a judge to be cognizant of that. But also it helps us understand how we're doing with respect to resolution of these cases. And in the final analysis, every month we get a report or run a report of how many cases we have in Marathon County. Between this year and last year, we're down about 5% in terms of the number of cases that we have. So can I say that that 5% is directly related to this program? No, I can't. But what I can say is that it's part of the solution. And if anybody wants the figures, I ran them off. I have them here somewhere. But you know, each judge is probably right now has probably roughly probably between 320, 400 cases, criminal cases only, assigned to them. And the idea is to continue to reduce that. The direct impact from the county's perspective is, of course, time people spend in jail. The other thing we were trying to do is reduce the number of people that you had to go out and get out of other jails. And I would also add this. I think it's imperative that you continue programs like this because there are other trains coming down the track. We have a crisis in terms of attorneys available to represent people who are, especially those who are incarcerated. To give you an example or to tell you the actual facts, we have 3 attorneys who will accept assignments that the county pays for. 3. And if you think of all of us as judges having 300 and some cases, 6 judges, it's not going to last. It's going to collapse on itself. These attorneys, you can't ask 3 attorneys to take all the county appointments. These are the appointments where someone asks for a public defender. If they qualify, the state gives them a public defender. If they don't qualify, because they have some limited assets or they had a job when they were brought in, then they can ask that we analyze their finances and appoint an attorney that the county pays for at $100 an hour. And then they have to pay back the county, but only after their case is concluded and installments based on their ability to pay. Every week, we are confronted with having to appoint numerous attorneys to cases, and we have 3 left, 3 attorneys who are still willing to take those cases. When that's over, when they're burned out, when they're done, we are going to have a problem because you're going to have people incarcerated, and then the question becomes, if you can't get them counsel, what do you do? If they don't have attorneys, no matter what type of case it is, can you continue to keep them incarcerated? Or if we keep them incarcerated, then our numbers balloon again as to what's in jail. So programs like we have right now with this eviction program, I'm giving you that as an insight into the future. We need to continue to do this and do more in order to free up the courts to handle cases effectively and keep that from becoming a problem. And I'm sure that if you ever were to ask Mr. Leonard, he could tell you how much money it takes to keep somebody out of county. Wood County, I was just there last year, as were some of the other judges, has built a brand new fancy jail. And I asked them why they needed it for such a small county, and they said to get checks from other counties. They're going to pay for that jail, in their mind, by counties who can't keep people incarcerated in their own counties. And if this problem continues with us not having attorneys to appoint, I don't know where we're headed with that, but I'm hoping that all of you are cognizant of this and will keep that in mind when deciding whether or not to approve programs like this that are only going to help you, and to consider additional programs to help us do our job effectively.
Are there any questions?
Any questions? Supervisor Wilhelm?
How much does it slow down the court system by not having the amount of attorneys? Is it increasing the length of what the court time is going to be? Not only to
So someone comes in. Oh, sorry. Yeah, I'm used to this. I don't know why I can't get that through my head. Someone comes in, and we have people here who know this because they're victims advocates, and they come in time and time and time again, and they can't get them an attorney assigned, and it can last months. And then you run into the problem with if they're incarcerated and you can't get them counsel, they have a constitutional right to counsel. What do you do? And we're under pressure because the appellate courts tell us, you know, as judges, you can't just put somebody in jail and say, good luck, we can't get you an attorney. We have to consider releasing them on signature bonds because we cannot get them. We can't comply with their rights. We can't get them. There's certain court proceedings that they get to have within a limited amount of time, but they want an attorney. Now you're denying them the right to have, for example, a preliminary hearing in a timely fashion, or you're tolling the time limits while you're trying to get them an attorney. And it puts pressure. Every judge can tell you we're constantly seeing people come up every week. Okay, here comes so and so. No attorney. Now, it might not just be the county appointment. The public defenders may not be able to get them attorneys either because there's a real limited resource when it comes to attorneys who are willing to work in counties other than, you know, down by Milwaukee or Madison. And even when we allow them to do things by video, they're not interested in taking the cases. This is not a Marathon County problem. This is a state problem, and it's extremely serious, and the courts are aware of it. And it's difficult because the only way to solve it is to get attorneys to come take the cases, and the attorneys aren't available.
have there been any conversations of solutions to this, or?
Yeah, lots of them down on the state level, judges, public defenders, everybody, and they have not come up with an effective solution as of yet.
If I can add to that, Supervisor Wilhelm, I actually have the great privilege to serve on a committee for it's a work group for the Wisconsin Counties Association on kind of rethinking how criminal justice system funding is viewed by the state of Wisconsin. There are a number of representatives from around the state to the point that Judge Strasser made. That's one area of part of the challenge, but the state courts, because they are state courts, are operated through this local, county, and state partnership. So Judge Strasser is a state employee. District Attorney Whetstone's in the back. She's a state employee, as are all the prosecutors. Counties fund things like correctional officers and jail through the sheriff's office. We also fund office staff for the district attorney's office and for the courts, and ensuring that there's enough resources, both one in terms of kind of green dollars, but number two, just people. There is a shortage of people, whether you're talking about attorneys willing to take any type of case, not just criminal cases. I think the judges would likely tell you that there's just a shortage of attorneys, particularly once you kind of get to the northern half of the state, for all sorts of cases where people would like some legal assistance. We just had a gentleman stop in my office yesterday, rather upset about his inability to find someone to help him with his case. So nothing, of course, that I or my staff could do, but I think it's a larger statewide issue. There are a lot of work groups on this, the state through the judges, the public defender, the District Attorneys Association, the state courts, the Supreme Court. They have a justice coalition that's been meeting for some time and has done a nice job, I think, when trying to balance the needs across the public defender's office, the prosecutors, and courts over the last several years. But the issue of how do counties fit in is still certainly ripe for answers. If you have any great ideas, I'd be happy to pass them along. But also, I would say, Judge O'Neill is in the back. She chairs the Criminal Justice Coordinating Council. She delivered a presentation to this committee some time ago, a number of months ago, about this very issue. There's a attorney white paper, a shortage of attorney white paper with kind of some things the county can look at.
All right, thank you.
Okay, thank you.
Okay, if there are no other questions, what we're looking for, similar to the last item, is motion to continue funding for the Judicare Mediation Service contract in the 2025 annual budget. Motion by Wilhelm. Do we have a second? Second by Mask. Any further discussion? Okay, hearing none. All those in favor signify by saying aye.
Aye.
Aye as well. Any opposed? Okay, that motion passes and it is unanimous. Item 6, on operational functions required by statute, ordinance, resolution, or policy. We have nothing under item A. We can move on to item B, discussion and possible action by the Public Safety Committee to forward to County Board for consideration. Item 1, abolish 1 FTE DA investigator and create 1 FTE deputy sheriff position within the sheriff's office by way of an interagency agreement between the district attorney's office and the sheriff's office. And I believe we have the sheriff and district attorney here. So.
Thank you. Just a little bit of background. The DA's office has had an investigator position for a number of years, as long as I can remember. A number of different people have filled that role, and over the years, that position has morphed in order to meet the needs of our community. The investigator that's currently in that position is a young officer who has a background in police work from the southern part of the state. And in her work now here is doing far more engagement and outreach than we've ever seen before, and does more work with agencies both here in Marathon County and outside of Marathon County than we've ever seen before, which is a huge help not only to the sheriff's office but to our rural police departments predominantly. What we've learned, though, over the last year or so is that the authority that that investigator has only goes as far as the borders of Marathon County. Unlike a sheriff's deputy who, when they get called or they move into a different jurisdiction, into a different county, there are mutual aid provisions that fall into place, or their deputy sheriff's status gives them the ability to go into a different county or area of Wisconsin without any issues. If you think about a prisoner transport as an example, those are happening every day here in Wisconsin, and there are deputies from all over the state that are going across our county highways and our state highways, and they have the authority to do that. The investigator in the DA's office does not have that same authority. They do not have that ability. Their ability stops at the county line. So if that investigator were to go down into Portage County to do work and something happened and they're carrying a firearm and wearing a badge and doing all of those things, and they assume they have the authority, they actually don't have it. So that creates a real hurdle for the DA's office. The other thing that we've noticed is that because of a lot of this work overlaps, we have 2 county departments that are in essence providing law enforcement services here in Marathon County, much like we used to have with the Parks Department when John Daniels, those of you who've been around long enough remember the park ranger position. When John did law enforcement services here in Marathon County for the parks, it became somewhat, I don't want to call it a conflict, but we overlapped in ways that we didn't have to. The DA investigator is required to qualify with a firearm. They're required to qualify with an emergency vehicle. There are other state mandated trainings that that person must have. And in order to get them, they have to come through the sheriff's office in order to have that taken care of. So DA Whetstone came to me probably 4 or 5 months ago maybe and asked whether we would entertain an opportunity to take that position from the DA's office, bring it into the sheriff's office as a deputy, and then assign that position back out to the DA's office as their investigator. But they would actually be a deputy sheriff. They'd have all the authority and power that a sheriff can grant to a position so they can effectively do their job without being hindered or, quite frankly, calling on the sheriff's office to back them up when they could actually just get it done themselves. So it reduces the duplication in services, and it also, and this is the biggest piece I think that we should all be worried with, it mitigates an incredible amount of liability in doing that work. because this person would now fall under all of the policies, the training, and the oversight that the sheriff's office can issue one time, whereas the DA's office now has to, in essence, mirror our policies and procedures and training and duplicate that again. By doing this, we mitigate a lot of that risk. So what we had done is we worked together. Chief Deputy Milhausen was a huge part of it, the DA, and we came up with an interagency agreement between our office and the DA's office that expressly lays out what this position will do and what it won't do. And largely, it will be to support the DA's office, to work with the deflection and diversion programs, to assist with domestic abuse response within the county, primarily the rural parts of the county and the smaller municipalities, and then other duties as assigned. I worked with the investigator actually last week on an issue that we had to resolve, and I think it will actually help bring some of that together. When you think about how that would all come together and we talk about the cost of doing that business, it's going to be about, if we look into 2025, about an additional $13,000 a year in order to move that position from an investigator to a deputy sheriff position. A lot of the equipment that this position would need, we already have, and that includes a vehicle. We have vehicles that are constantly coming and going and cycling, and we would just hold one back from auction for a while. So as you look at what this would look like into the new year, it's an increase of about a little over $13,000. When we talk about timing on this, we believe that it's imperative that we do this sooner than later. And if there is a decision on the part of the committee and ultimately the board to abolish a position in the DA's office and create one in the sheriff's office, what would happen is we would have the funding flow between our two offices, and any differences for the remainder of this year would be made up within our budget through the attrition that we currently have in our positions. So funding for this year would not be an issue. Anything I missed, Teresa, you want to fill in the blanks on?
I just want to thank the sheriff for being willing to work with the district attorney's office on this. So this has been a long-term vision for the investigator position in our office, and for a variety of reasons it hasn't been able to happen until now. So development of the position within our office was the first step, but the second step was really looking at where we can collaborate with the sheriff's office, use their resource, use all the protections and existing resources that they have, and use this position to its fullest extent. So we have the statutory authority in the district attorney's office under the district attorney's authority to have an investigator. So it's not that I couldn't have an investigator continue the way we currently have it, but is it the best use of our resources? Is it the best way to minimize liability that we talked about? So when we met, this is exactly how I would hope the criminal justice system would work. It wasn't about me keeping an employee and being territorial. It wasn't anything like that. It was a collaborative effort to figure out what is the best way to use this resource, minimize the liability exposure, and get the best outcome for investigations, for response to victims in this county. And I'm so appreciative that we could work this out, and there wasn't any egos involved, there wasn't any territorialness involved. It was just finding the best way to make this happen. So I'm appreciative of county administration for working with us on this too. So,
Any questions? Supervisor Opel?
You said that, Sheriff, you said that you mentioned that the 13 grand or so difference would be absorbed through your budget.
Not the 13 grand, what the remainder of this year would be. So if this doesn't start till September, we're probably talking $3,000, $4,000, $5,000 for the remainder of this year. That 13 grand is the number for 2025.
Okay, and where would that additional money come from then?
New money.
New money.
New money.
Oh, boy.
Yeah, from you, actually.
Yeah, this is the point
All
where
right.
they said they liked working.
Sign me up. I'll make a motion to approve.
Thank you, sir.
We do have a motion to approve the request that's before you. Do we have a second? second by Mask. Any further discussion?
Mr. Chair, can I just clarify just a little bit on the process? So under your ordinance, I know it's inherent in the motion and the second, but the motion and second would be to forward this issue, the abolishment of the 1.0 FTE position in the district attorney's office and the creation of the 1.0 FTE within the sheriff's office to the HR Finance and Property Committee for its consideration, consistent with section 4.20 of your ordinances, and then on to the full county board.
That's exactly what I was going to say.
I understood that to be inherent in it.
Okay, and is that exactly what you were going to second? Yes. Supervisor Mask seconds. Any further discussion?
So with the extra $13,000, is that for training, make the person become full-time, or what is the extra money for?
Wages. So what you're doing in effect is you're moving the investigator position, which is paid at one rate, to a deputy position, which is covered under the bargaining agreement. So there's a rate set at that. So it's that difference between the two.
And if I can just clarify, from an administration perspective, again, I'll echo everything the sheriff and the district attorney said. It is going to cost the county additional funds, but as was alluded to, the liability, the mitigation of risk, I think, is really important. It should enhance stability within that position in terms of stability with respect to skills because of the existing policies within the sheriff's office, the fact that the individual will have training consistent with the rest of the peers, have knowledge of the system, because again, the sheriff's office is recruiting these positions. It is very similar to what we did with the Parks, Rec, and Forestry Commission, Parks, Rec, and Forestry Department a number of years ago. It ensures that we have that, for lack of a better term, pipeline. I mean, these are individuals that are existing deputies. They would apply for, essentially, special assignment to the district attorney's office, which, if you ask me, in administration, I think is a good thing. I reflect back on my experience in the district attorney's office. It's very good to have someone out in a deputy position have that intricate understanding of how things work, kind of on the, hey, once I'm done with the case, what does that look like on the court side, I think is great. And DA Whetstone with the idea of transitioning this position or emphasizing within this position to work very closely with the training and education inherent with our smaller departments particularly. I think relying upon someone that has that built-in experience and relationship through their work in the sheriff's office is really a smart way to do it. But does it cost you more money? Yes. From my perspective in administration, we can spend less and do a poorer job, or we can, be proactive and have a, not that we're doing a poor job, we're doing a really good job, but this is kind of continuing to evolve that position.
Any further questions? Supervisor Sandelsky.
Yeah, would that be able to be funded through that, last year we had that social improvement fund, we had such an excess. Would that be able to be something that could be funded through use of that money instead of adding on to the tax base?
Well, in short, any reserve fund that is not restricted, you can use for a wide variety of purposes. Under your existing policy with respect to the social improvement fund, that's going to roll over and populate your capital improvement fund for next year's budget. But just to clarify, there's no way for us to increase the tax base through this position. We'll have to find a way to fund it within the existing increases that are going to come from net new construction. So it's not like there's a new money from some other source, although shared revenue is, if you think back to the legislation last year in the state of Wisconsin, there's a requirement for a maintenance of effort relative to law enforcement funding. This at least certainly is consistent with the intent of shared revenue. I know that's probably not a short answer to your question, but I mean, I'm not overly concerned. This is $13,000 of kind of hard money. We'll work it out. Chad and I are going to have, I should say, Sheriff and I are going to have great conversations about their existing budget.
Any other questions? Okay, we have a motion and a second on the table, and I'm not going to repeat it. All those in favor? Aye. All those opposed? Okay, carries. Thanks for the presentation. We can move on to item 7A, update from the DA's office on deflection diversion grant applications.
Hello. Yes. My name is Ruth Heinzel. I'm the diversion supervisor in the district attorney's office. I just wanted to give a really quick update on some fast turnaround grants we applied for. So the diversion and deflection team applied for 4 grants. 3 of them are to expand the deflection program that has been going really well. We kind of did a presentation on it not too many months ago. And the other one is to expand the regular diversion program. So one of the grants, we're looking into expanding the deflection program is to do a team of a person that's a deflection specialist that meets with the participant and helps them connect with treatment, along with a law enforcement officer that could, it's kind of looks more similar to the CART model where they show up together on the scene, maybe after an overdose or somebody that has a lot of calls for service. They would show up and try to help that person connect with services instead of being a high utilizer of the system. And then one of the grants we applied for was to help with the downtown unhoused population, to help connect a lot of those individuals with treatment and work with their housing specialists to connect them with housing. And it's just a more comprehensive way to deal with that. And then the next one is more of like a outreach person that can try to get people before they end up in the criminal justice system. So they would have like office hours at the emergency department, at Community Partners Campus, at a bunch of different places where people who have some kind of substance use disorder or substance use challenges can go to this person to get help and funding for treatment. So there is no, I'm not requesting any money from anybody. We're just, the $2.5 million goes over 3 years. And I just wanted to let you guys know that we're asking for this funding for the 3 years, and then we don't know if they'll be extended after that, but we can see at that time. And then Nikki will go through the next grant.
Hi there, Nikki Delatolis. I'm the diversion specialist within the district attorney's office. So presently, we have a pre- and post-charge diversion program. So this is an expansion upon what is existing within the district attorney's office. We, to some degree, have what we call a pre-filing diversion track already in place in the office, but due to current staffing, have not ever been able to make it a true caseload. So what that looks like is this tailored prosecution, or something a bit more innovative, would take a normally 9-month process within the court system with 4 or more hearings down to 60 days and 1 hearing. The different tracks that we're proposing within this pre-filing diversion would be a veterans track, a mental health and substance use disorder track, and what we would broadly consider other cases as appropriate. So this grant would pay for $300,000 over a 3-year period that would fund the 1 position with no other expenses at this time. So the specific organization of this part of our program would have that individual putting together a specialty team to review all of the surrounding information on a file, present that to the prosecutor for that offer to be tailored. Then that individual, the new diversion specialist, so to speak, would reach out to the alleged offender, notify them of this referral, allow them the time to get an attorney if they'd like one, then schedule a meeting for that individual, their attorney, and the prosecutor to go over this potential offer. Then, upon, say, acceptance of that offer, 1 hearing is scheduled in which the initial appearance, the plea, and the sentencing happen all at once. All of the information being above board, discovery exchanged, etc. And that's everything. Is there any questions?
Any questions about anything? No questions means we did our job. Yeah. Yeah, go ahead.
This is just to approve the grant?
Nope, it's
Oh,
just a
just us.
FYI that we applied. We don't know if we're getting the grant. So last year, I mean, the grant period starts October 1st, but last year when we applied for a grant, we didn't find out until midway through October due to budget pushing. So these are all federal grants through the Bureau of Justice Assistance. So whenever the federal government makes their decision, we'll know whether or not we get it, and then we'll come in front of the board at that time to get approval for whichever grants we get.
Thank you.
Yeah. Anything else?
Okay, thank you. We can move on then to 7B, Marathon County Assembly's Ordinance 12.04. This is just a review of draft update, and I turn that over to our folks headed to the front.
Yeah, we have Shad Harvey and Garrett Poggle from Conservation Planning and Zoning. So for those of you that have been on this committee for a while, you've heard about this before. This actually, I was thinking about how to kick this off, and it occurred to me this started back in like 2019. These conversations started about our large assemblies ordinance. At that time, we had there was a thought that we were going to have more large groups. Think about like the Wausau Marathon or Triathlon. So the focus initially was sporting events, but just general large gatherings of people that might require assistance from various county departments, most notably the Sheriff's Office and our Highway Department. So we started down this path of considering how we might create an ordinance to provide some framework to assist in the planning and execution of these events. And lo and behold, we found out we already had one in 12.04. However, upon further examination, this was more recently, in conversations with Corporation Counsel Purner, we looked at our existing ordinance and some of the case law that has come down, cases that have examined these sort of assemblies, and our existing ordinance is two things. One, it is ripe for update based on that case law that raises some question about some of the time frames and their interplay with the First Amendment. And second, it is something that we're not following right now. We haven't, quite honestly, as far as I can tell, it's not been followed for a great many years. So we had a work group that was formed last year or the year before with members of this committee, with members from the Infrastructure Committee, and members from the Environmental Resources Committee to try to look at, from a policy perspective, again, this is an ordinance, so it requires board action, a review of our existing ordinance and update that based on what we see in other counties and what this county, in terms of its elected officials, that work group came together with staff serving in an education role, an information gathering role to update the ordinance. So we have Shad and Garrett here to walk you through kind of where we've come from and where we are and what are the next steps. So I'll turn the mouse over to Shad.
Thank you. Like Administrator Leonard said, I'm Shad Harvey. I'm the Land Resource Manager for Marathon County. And this is Garrett Poggle, our Land Use Specialist. So we're just going to kind of go over just some general updates of where we're at and some basics about the Large Assemblies Ordinance. So the reason for the update, as Administrator Leonard said, was our Corporation Counsel kind of did a review on it, and it's unenforceable due to some constitutional concerns. So we wanted to make sure we got those addressed in the update. The county board did place this on Administrator Leonard's work plan for 2023, which kind of kicked off the planning stages for this ordinance. The work group that was developed, essentially the work group was tasked to discuss if Marathon County should regulate large assemblies. It's not a requirement that the county does regulate it, but they wanted to have those discussions to see if that was something the county wanted to do. And then if they chose so, to analyze and create an enforceable ordinance. The work group members included the STEAM Show, Taste and Glow representatives, the Environmental Resource Committee, Public Safety Committee, Infrastructure Committee, and then a bunch of Marathon County staff from CPZ or Conservation Planning and Zoning, Emergency Management, Health, Parks Recreation, Forestry, Highways, and the Sheriff's Office. So just kind of just an overview of what's happened, a timeline. In June 2023, the work group was organized. September, October of 23, the draft was distributed to the towns to try and get comments, and to the committees to try and get comments on their thoughts. In October of 23, we did presentations at the Towns Association meetings. November through January of 2024 was kind of our drafting period where we drafted the revisions. November and December of 23, we presented to the ERC Committee, Public Safety and Infrastructure. February of 24, presentations to County Board. Towns were notified of additional comments and opportunity to provide those comments. And then March of 24, we met with the work group to make final revisions in preparation to make the final presentations to the standing committees and County Board in the summer of this year, 24. So just some summary of input or some conversations that came from the input that we received dealt with the purpose of the ordinance, the threshold or the applicability of the ordinance, some security concerns, implementation and appeals of permitting, and then of course fees that are associated with them. So through the work group and the discussions, along with the comments, there was a purpose of the draft ordinance. The one that was brought forth was, and in the proposed ordinance, the assembly of large numbers of individuals in excess of those who would normally be requiring the services of the health, sanitary, fire, police, transportation, and utility agencies which are regularly provided in the county. And then the regulation, the assembly of large numbers of individuals in excess of those who regularly occupy the event location to minimize adverse impacts on surrounding properties and uses. So the applicability, so where would this ordinance be in effect? So where? All unincorporated areas of Marathon County regardless of zoning status. So this would be in all townships in Marathon County, excluding cities and villages. Cities and villages have their own powers to regulate these types of events, so this would only be for the townships of Marathon County. And why? The objective is to protect people and the resources of Marathon County. So one of the things that was discussed is the threshold for application. When would this apply? What events would this apply to? Currently in the ordinance that we already have in the books, the threshold is 3,000 or more. Through the work group discussions, they decided to keep it the same just by clarifying a little bit more. So as it sits in the proposed draft, it would be 3,000 or more attendees at any one time or an aggregate over the course of an 8-hour period. So in the ordinance, there are certain exceptions that are listed. So these would be things where they may meet the 3,000 people mark, but they don't have to apply for a permit. Those exceptions are if there's an established place of worship, a stadium, athletic fields, arenas, auditoriums, coliseums, or where a business primary product of that business is providing the regular event space. However, it must be correctly zoned and have all the necessary permits, whether that's town, county, state, or federal. A few more exceptions. Fees shall not apply to government-sponsored events held on government-owned property where the proceeds are returned to the government or community, nor to assemblies required to be licensed by other laws, rules, regulations, or ordinances and regulations of Marathon County. Just as a note, this doesn't exempt an organization from any other local regulations or any other zoning ordinance in effect where the event is taking place, so there may be other requirements they need in addition to the assembly's permit. One of the things that was brought up was security concerns as well. The draft ordinance contains requirements for security based on the size of the event. It does require that the security for the event those security officers or individuals in charge of security there be registered and have a background check. The draft ordinance, I think one of the key things is to help protect the people and the resources of Marathon County, not just from the events we know are going to happen or know they occur, but the ones that might pop up and not have as much experience planning those events. It's kind of that guiding tool to help them plan a safe event for Marathon County to enjoy. So implementation of the ordinance, that was a big thing for discussion. There's been FAQs, resource guides, example plans available for an applicant that's creating their application to kind of help them through the process. All applications to try and streamline the process would be submitted to CPZ or Conservation Planning and Zoning, and then CPZ would distribute that to the other departments that may have interest in the events as well. The health department permits would remain separate permit applications. However, CPZ and the health department will work together to try and coordinate that permitting process. The goal is to make it a little bit more streamlined so the individuals that are planning these events don't necessarily have to go to 20 different places. They can kind of come to one, and we can facilitate the conversations between departments just to make sure we know they're getting what they need. And then there's a suggestion to evaluate the ordinance after 5 events. I know historically there was a suggestion that maybe we evaluate after 1 year of the ordinance being put in effect. The 5 events was chosen essentially because we don't know how many events we're going to have in 1 year, and if we only have 1 or 2 events that this applies to, it doesn't really give us a great sample size as far as how the ordinance is working or things that might need to be changed. So the 5 events would give us a sample size to say, okay, this is a common thing that's happening and we need to address it after those 5 events. It could take a year to get to the 5 events. It could take more than 1 year. So issuance and appeal process, according to the draft ordinance, an applicant must submit at least 40 days prior to the event. And then CPZ would go through that permitting process, the review, again, submitting it to the other departments that may have interest. And then a decision would need to be made by the department 30 days, within 30 days of it being submitted to the county. There is an appeal process to this. The appeal, individual that can make an appeal, individual, group, or organization to whom a license has been denied may appeal that denial. A township in which the event is intended to take place may appeal. Must be submitted within 5 days of permit issuance. Again, this is a timing thing to make sure that we're following case law and state statute, making sure we're not holding up an event that can't be held up. The appeal cannot be based on content, message, or viewpoint of the assembly. It has to be based off of public health and safety or items that fit into that category. And then Administrator Leonard gets the joy of making the decision of the appeal when it comes in, and he would have 5 days to make that appeal decision. Towns would be notified when the applicant is submitted to make sure that they have adequate notice if they are looking to appeal. They would be notified once the permit is issued, so they would have ample opportunity to submit the appeal if they felt necessary. So another big item was fees and recovery in the draft ordinance. The applicant shall submit a fee for the assembly permit. Right now, our assembly's ordinance that is on the books does have a fee schedule found in 12.01. It's essentially, there's already fees laid out. For example, right now in the ordinance that's already in there, an event that has 3,000 people but less than 10,000 people is a $500 fee. If you're at 10,000 people but less than 25,000, it's an $800 fee. And then 25,000 to less than 50 is $1,200. And then anything over 50,000 is $1,500. A lot of the discussions we've had, we would be more or less looking to go to one standard fee based on the review process that we have. A review of an event that has 3,000 people versus 50,000 people, it's still the same review process. So we would right now, the fee is set up in a step structure, but a single fee would be something that I think would be, one, easier to monitor, and two, would be, it'd be simpler for the applicant. They'd have a set fee that they would have. Additionally, there is some language in the proposed ordinance for fee recovery for extraordinary services. So events that require county-owned materials and/or staff labor, they would negotiate with the department in which has to provide those services via a separate contract, just to make sure the county is getting back some of the costs that they have associated with it. So if the sheriff's office was requested for their services at the event, they would work with the sheriff's office to determine what that would look like as far as if they would need extra services and how much that would cost. So next steps, the next steps on here, I'm just going to kind of clarify a little bit. Right now, the ordinance is going back to the work group for some a little bit more discussion. We'll be talking about, one, the fees, and then as well as making sure that we get some input from the dairy breakfast as well. There was, ERC committee had asked that we contact the dairy breakfast to get their input, because they may, depending on some of their events, they may meet the threshold for the 3,000. And I know Sheriff Billup, you had some extra stuff I didn't know if you wanted to add at this point.
The only thing I added at the last group was, ironically, as we were working through this, I happened to be at a conference with the sheriff of Walworth County, and we were making small talk about all the concerts they have at Alpine Valley, and I said, how on earth do you manage that? How do you staff it? And he said, well, it's all through mutual aid agreements, and he brings in deputies from all across the region in order to do that. And then I said, well, how do you recover costs and so forth? And what they do in Walworth County is, if there's an event where they charge an admission, by county ordinance, there is a fee that's attached to each ticket. So let's just say it's $1. So for each ticket they sold, they would charge an extra $1. So instead of the sheriff coming in and saying, you have to pay us $15,000 for the services we provide, they would just give you that $1 they collected from the ticket sales to put towards whatever your services were. In Walworth County, what that looks like is, if they have to pay Kenosha, if they have to pay Greene County, whoever it might be, for assistance, they take it out of that pot. If the highway department has to do work, they take it out of that pot. And it just becomes a revenue line for them in order to help support these large events that take place. If the event isn't a success and the fees that the sheriff has are over what they collect at the end of the year, the sheriff sends that organization a bill, and then they can work it out however, but that's what their ordinance says. What that ordinance eliminates is, if we had a large event here in Marathon County, and let's say they were expecting 30,000 people, and the sheriff's office said, well, we think we need 10 deputies, and the organizers say, you don't need 10 deputies, you need 2. Well, where do you draw the line? And how do you not get into a squabble? If you just do it by assigning an extra amount to the ticket sale for those ticketed events, that would resolve some of those issues. So it's an idea that I asked the committee to look at and explore, because it's being done in other communities.
Sheriff Bill, don't you get into a squabble at the end then if you the event didn't make enough money and you send them a bill, and then perhaps at the end they say, well, oh, by the way, you had too many people there?
I'm sorry, I don't understand the very last piece of that.
So for instance, I understood in Walworth, if, at the end of the year, they didn't, you're going to send them a bill because there wasn't enough money in the pot. You do foresee squabbles then at the end of the year because
in those situations where that happens, I think it's inevitable. But you're definitely going to have one. If I say, you need 10 deputies and you think you only need 2, we're going to assign 10 because that's what's right and that's what we need to have a safe event.
Sure. Administrator Leonard.
Yeah, thank you, Mr. Chair. Just to kind of elaborate, I think this conversation is good, as the sheriff referenced. The idea is to go back to the work group on that issue, and security was something we talked a lot about. Security, and just to add a little bit more context, the ratio that Shad referenced, that's the current ratio in the ordinance. So it's not as though the 3 to 1,000 of licensed security came out of nowhere. That's in your current ordinance. But the discussion, to your point, Mr. Chair, about ensuring that there's clarity, as well as what the sheriff referenced, there's clarity between, primarily with the organizer and with us in a review capacity of what their plan is. We're not going to get into the, quite honestly, our ordinance doesn't care if you have 3 licensed security people or you pay the sheriff's office or any other municipal police department to serve as security. You got to have a plan. The whole point of this ordinance, as Shad referenced, we're less concerned. The STEAM show had representatives at this, at many of these meetings. And I think rightly pointed out, like, hey, they've been running that event for longer than I've lived here, for sure. But it's more the events that it's, hey, the first time they're putting together a plan and all the things we want them to think about. This ordinance and the accompanying documents that CPZ and other county staff are going to put together are planning tools. It's to make sure that they think about severe weather. We had some severe weather at the out at the balloon rally event out in a rural part of Marathon County, and part of our ordinance is give some thought to how you're going to handle that. Make sure your traffic patterns and your parking plan will accommodate people getting out of that area relatively quickly, and have it. It's not great when you're trying to figure out what to say about severe weather when the severe weather is there. But our planning documents will have essentially, hey, what's your script and how are you going to disseminate information about severe weather coming into the area for these events. And so it's just helping to think through some of the things that otherwise you might not think through. Sometimes they're really sexy topics like severe weather, porta potties, and how many garbage cans you need. But if you haven't run an event before, they might not be things you think about. And again, the other thing that I think the work group, the county board supervisors really made very clear was we want it to be more efficient than our current process, which, as Shad alluded to, we were trying to get it so we have people know who they need to apply to. We then disseminate the various pieces of their plan to the departments that would conduct that review. If they're going to do temporary camping, right? The health department does that review. We will make sure the health department gets it and that they conduct that review quickly, as opposed to trusting an applicant to know where they need to go for a lot of those things, which if it's your first event, you probably don't know.
All right, so right now, are the towns able to, because we had a town chairman, we were going to vote on this, and the town chairman came in extremely upset with the Q&Z Expo Center. Now, can they have an ordinance or something to oversee this right now with us not enforcing it? Can they have an ordinance over this, or is this something that, because I don't want us overstepping them and then all of a sudden vendors are able to do things that the town didn't want. And because then one other thing besides that is the town town of Berlin, I talked to a couple of the officials to see what they got for information. And one, because you guys said you sent out an email, and one, she's like, I don't know if I got it. So the rest of the town board members didn't even know anything about it. And I would like to see some communication with them on this, because I'm not going to go contact every single town board to tell them what's going on with this. I want them to know in case they need to contact us because they don't want us voting for something or to give us some direction that they want. But if you could give me a little bit of heads up on if the town can have an ordinance on this right now.
Yeah, so there's several things that kind of come into play. For example, is a township county zoned? Is a township town zoned? Is there no zoning in that township? So for example, county zone towns are under our Chapter 17, which there are some regulations as far as events, depending on what's going on. Like right now, we have a special event policy where somebody can have a special event, 3 a year, depending on their zoning, of course. But as far as like a town, so they would be under that. As far as another ordinance that a town could adopt, I believe towns can have licensing ordinances as well. I believe if they were to have like an assemblies ordinance per se, they would be running into a lot of the same legal things that we have to look into when we have an ordinance, making sure it doesn't affect people's freedom of speech, things like that. So that's something that they would have to work with their legal counsel on. As far as an ordinance to restrict assemblies, that's something that I'd recommend they reach out to their legal counsel on to make sure that they're making a sound decision on. I know townships can have noise ordinances as well if that's their concern. They can have things like that. They're licensing ordinances, not necessarily zoning ordinances. But there are things that they could put in place. They just have to be careful as far as what they restrict. So they'd have to definitely contact their legal counsel. As far as the notifications to the towns that was sent out, and this is how we do all of our public notices and stuff, whether it be posted in the paper, but we also send everything out to the town clerks. We have the list of the town clerks, and then generally it goes to the town clerks, and the town clerks distribute it. We're happy to take comments from towns if they have them. I mean, if you know of anybody, an individual that hasn't received them, you can definitely have them reach out, and we can get them the information so they can provide comment to us, which we can bring up at the work group as well.
One thing I'll say you gave an example, and maybe Shad, if you can talk through the idea that the towns can adopt an ordinance relative to an expo center. I mean, this ordinance, going back up to one of the previous slides, does it govern the Q&Z Expo Center?
So as far as the Expo Center or something like that, if that property has a conditional use permit, whether that be through county zoning or town zoning, if it has the proper permitting, this ordinance wouldn't apply to them because their business would be holding events.
What he was concerned about was them having, because it was their indoor events, what he was concerned about is it turning into an outdoor event and then having larger crowds based on the county ordinance versus what the town had.
So they would still have to, so as mentioned before, how this doesn't supersede other ordinances or whatnot. If, for example, if the Q&Z Expo Center had a conditional use permit that said they can only operate indoors with stuff like that, that doesn't mean their zoning might not allow for that large outdoor event. They'd have to go through other permitting avenues to get that as well. But did you have something you wanted to add?
So on the Q&Z Expo Center, I know one thing that the town did is they restricted their liquor license so that all events have to take place within the building. And if they violate that, the town then has the power to revoke the liquor license. And at this point, I believe it is a bar or a tavern. So at that point would render the building and the use void. So they wouldn't be able to operate anymore. So that's one of the powers that the town has a great amount of authority over is the liquor license.
And then if I can just add one other thing for context, talking and I'll say this when we get to the county board after the work group comes up with their recommendations and assuming it comes out of a committee. Certainly the policy decision absolutely is one the board needs to make, but your existing ordinance, please do not leave it. It has areas that are unenforceable. If the amendments ultimately don't pass, hey, I'm your administrator. Quite honestly, you tell me to go to the moon, I'll do my best to get there. You want us to regulate in this space, we'll regulate in accordance with the policy you set, but please do not leave an ordinance that has constitutional concerns that has not been followed for years on the books. We have to fix that. So I'll say that at the board as well, but if you do have questions, concerns, if something occurs to you after this meeting, please reach out. Again, the work group has done a very good job. You have a number of county board members that have participated, and we always notice those meetings. So if anyone wants to attend, you're certainly more than willing to do that, or more than able to do that.
Supervisor Opal?
As I'm sorry, as Sheriff Billup expressed, I honestly think that would be a very good addition. A ticket charge on the ticket price, and I think it would be good to incorporate that.
Supervisor Sandelsky?
Yeah, I just have concerns with the First Amendment stuff, and also, like, if there could come a time where a lot of people don't look at it, like where people may have to, like, assemble, like peaceably assemble, and they don't have time to, like, inform the county and that, and they could get in trouble for this, and they may have to come a time where people don't look ahead to the future of things going on in the world, where people may have to have a time. So at this point, I don't think I could support that's all I got to say. Thank you.
And then at this point, this was informational, no action on our part. Okay. Any other questions or comments? All right. Thank you both. We can move on to item 7C, review of 2024 second quarter budget to actual reports for departments of oversight. This was within your packet. Any comments from the administrator?
Well, I'll happy to answer any questions, or probably more appropriately, take any questions you may have and try to research what you need from me. But I'll say, I said this at Health and Human Services, and I've said it at each of the presentations. We know there are some mapping issues when we implemented our new enterprise resource planning tool that we need to clean up, and our new finance director is aware that it's going to take us some time. That said, I'm very happy to report we're able to run these reports and bring them to you. We are going to evaluate how to do it a little bit differently, but how I use them, how I have used them thus far. The thing, the sheriff made mention of this before, really looking at our personnel budget. You're halfway through the year with these reports. They're through June because we, of course, have a payroll lag. We don't pay you each and every day right after the day you work. There's a little bit of a lag. So you want to be in that somewhere between 40 to 50%, assuming we're not budgeting for attrition within each department for personnel. And for these departments, you largely are. The other piece to keep in mind is that sometimes some of the line items, again, for mapping, just to give you an example, I think I said this the last time, the employee benefit line here, yes, 485% of budget. It's a small dollar amount. That's a mapping issue we'll clean up moving forward in terms of where we had an employee benefit contribution mapped through our system. But overall, there's nothing concerning. I sat down with the deputy administrator yesterday and the finance director. I don't think there's anything concerning we've seen in financials from a budgetary perspective. Certainly from a kind of looking at how do we want to lay out the financials moving forward. We have things to work on, but departments are doing a good job. We'll have these discussions when we start planning for the budget. Where are they at budget to actual throughout the year? From an expenditure standpoint and from a revenue standpoint, one thing always to keep in mind is we are not an organization where you kind of look at each month's financials as 1/12 of a year. Our roadway maintenance budget is not equally dispersed throughout the year. We plow roads in the winter, and we do a lot of fixing in the spring and roadway maintenance in the summer, but there's sometimes when expenses don't hit and we don't pay for things all at the same time. I'll give an example. In my budget, I have all the nonprofits that you just heard from two today. $238,000 is a line item in my budget, but it's for funding those nonprofits. As soon as the budget's adopted, January rolls around and they promptly send me a letter asking for payment. So I'm about 90% expended through the budget in the first quarter. That's not concerning because I'm not paying them each and every month or every quarter. They get paid once annually for those service contracts. But if you do have specific questions about any particular department, happy to answer them. I know one thing for the clerk of courts budget. Kelly and I have talked a little bit about it already. We're going to have to look really closely at our interpreter fees and how do we budget accurately for that. Those costs have just gone up immensely during this year, and that's not a Marathon County problem. That's a state problem. That's one of those things I'm talking about in that work group as well. The other part with some of the budgets as we clean them up is they have a grant budget and an operating budget, which can make budget evaluation for you, I think, a bit challenging. So we're looking at how to do a little bit of that differently. But overall, again, I don't have concerns. I'll just tell you with respect to budgeting for 2025, the medical examiner's budget, our plan is to budget largely status quo from a staff perspective, but please understand that with the opening of the new facility, we are going to be bringing a very large budget amendment through in probably the first quarter of 2025, once we really understand what the staffing and organizational chart is going to look like. But long introduction to say, please let me know if you have questions, but nothing concerning from my perspective or from the finance director's perspective at this point.
Any questions for the administrator? Okay. Oh, I'm sorry, Supervisor Sandelsky.
So is this just for the second quarter budget? No?
It's
You're just reviewing the second quarter?
through the second quarter, so not
this
just
year.
the second
Okay.
quarter, but first.
This ain't for next year's budget then? Okay.
No.
Okay, thank you.
Supervisor Wilhelm.
I just had a question. How much money do we have in reserves?
We'll have the audit presentation to the HR Finance Committee tomorrow. So I can get you those numbers. I don't have them in front of me, but the audited financials for 2023 are in the packet for HR Finance tomorrow.
Okay, if no other questions, we're down to item 8, next meeting date and time. Committee members are asked to bring ideas for future discussion. Mr. Robinson.
We might have an opportunity. Thought we might have an opportunity today to talk about the potential for CART expansion, the crisis assessment response team, which we brought in the past. If we could put that on the agenda for next meeting.
Okay. And then anything else? Okay. We're moving on to item 9, Supervisor Opal. Do we have a motion to adjourn? Okay. Do we have a second? Second by Supervisor Wilhelm. All those in favor? Aye. Okay, thanks.